international NGOs as well as environmental NGOs. They are generally accepted by the state, we have to say. This was not so much before, maybe around 20, 30 years. And since they first complement state capacities, and they also function as something like a valve, ventil for the people's anger in cases of environmental damages. But nevertheless, they are also confined and supervised by the state, because the state fears their potential first to harbor dissidents, and also fears their potential to become independent forces in the PRC. And finally, they seldom have a confrontative attitude towards the state. So right now I would like to tell you something about the legal functions of these environmental NGOs, of these green NGOs, with respect to law. So for instance, they participate in the lawmaking process. They cooperate in law drafting. For instance, in 2006, Greenpeace and the Chinese legislator shaped together the draft for the Renewable Energies Law. Or once more, Elizabeth Economy says that ordinary citizens even participated in drafting the law by sending in, it's a Shenyang regulation, by sending in comments after a draft law was published in a local newspaper. This actually has not so much to do with lawmaking processes by NGOs, but it nevertheless shows that the public can participate in law drafting, law making. And by the way, this sending in of comments is also a socialist tradition. For instance, with respect to the first Chinese constitution of 54, there were also comments sent in for this law. And a second point is that NGOs identify and correct also legal loopholes, Gesetzeslücken, and legal mistakes, Gesetzesfehler. So there's a case of a windmill, and it goes as follows. There once was a regulation in China, and this regulation stipulated noise measurement procedures for windmills. And the problem is right now that these regulations stipulated that the noise should be measured when there was no wind. But the problem is, as you can imagine, if there is no wind, the windmill won't work. So this might be a little bit of problematic. And then some people went to the center of Wang Canfa and they talked to him, and yes, Wang Canfa finally identified this legal mistake and corrected it and made a suggestion to the Chinese legislator on the respective level, and then this mistake was solved. This problem was solved. So this is an example how NGOs, like the NGO of Wang Canfa, can cooperate in the law making process or law improvement process. Another issue is the participation in the law enforcing process. So of course they exert public pressure on non-law abiding polluters. So they have a function as a watchdog and as a whistleblower. They also raise environmental consciousness, 环境意识, especially rights consciousness, and they litigate, like the Center for Legal Assistance to Pollution Victims, and of course other activities. Okay, so right now I would like to talk about the second issue, which is called environmental impact assessment. So Umweltverträglichkeitsprüfung, or 环境影响评价 in Chinese. So what is environmental impact assessment? Here we once more can find a legal definition, 法定定义, in Article 2 of the respective law, which reads, the environmental impact assessment referred to in this law means a method and system for analyzing, forecasting and assessing the potential impact on the environment after implementation of plans and construction projects, for putting forward strategies and measures to prevent or alleviate adverse impacts on the environment, and for carrying out follow-up and monitoring. So I right now would like to have a closer look on the key terms. So the first key terms are analyzing, forecasting and assessing. So these are three different steps and they are consequence steps. So one step can be made only after the first step. So first analyzation, then forecast, and finally assessment. And the second two terms are potential impact. So as you see, I stress potential because it is not only meant by this law the damage done, but also the possibility of a damage. So the danger of a damage is regulated. So this is what we in German call konkrete Gefährdungsdelikte, concrete endangerments, 具体危险犯罪. And with respect to the potential issue and with respect to the impact, so the danger, we can sum up that these are so-called result crimes, Erfolgsdelikte oder Verletzungsdelikte, 结果犯罪. And yes, I cannot go more into detail here, but I will tell you more if you want in this extra liability video that will be put online in around 1 or 2 weeks. So the next key terms are plans and construction projects. These are, as you see here, both plans and construction projects have an own chapter. So chapter 2 is the plan chapter, and chapter 3 is the construction projects chapter. Okay. And then the next key terms are prevent or alleviate adverse impacts on the environment. So here we have the main aim of this law is to avoid, of course, negative and damaging impact on the environment. But it is also recognized by the legislator that sometimes pollution exists and then it must be alleviated. So it must be reduced, then limited and regulated. The next few terms are follow-up and monitoring. This has to be seen in the broader context of sustainability, of course, because if you only once check a factory, this and not twice or more after, so more follow-up controlling, then this has of course no sense. So this is also very important. This I will leave out. And right now let's have a short glimpse on the structure of this law. You see once more a general provisions chapter, as it's usual in law, then this plans chapter, projects chapter, and once more also a legal liability chapter, and finally supplementary provisions. And right now I cannot go into detail about this law, but I just want to talk about this chapter 3, so the appraisal of the environmental impact of construction projects, Aufbauprojekte. There exist 3 kinds of environmental impact reporting. So the first is environmental impact reports, these Baugausschuh, and then environmental impact report forms, these Baugaubiao, and then registration forms, 登记表. And the first one, so these impact reports have to be made in case, as the law stipulates, in case of a major potential environmental impact. The second one, these impact report forms, has to be made in cases of a light potential environmental impact. And the third one, the registration forms, has to be made in cases of very small environmental impact. So there's a hierarchy, a pyramid of a reporting system.